about what she talked about, because I couldn't really follow, maybe because of my intonation. I was just trying to read the slides, but you will see that my work today, my report today is based on what she taught before, because I went further to read a little about how domain name relates to intellectual property or trademark. But it was very insightful. Just that we didn't really get. We couldn't even ask questions last time. I think a lot of people were still trying to figure out, and we're so slow following the slide because she was talking so fast. I was trying to figure out something, but it was all right. It was fine.
Okay. I think she sent the slides, so I would forward it to the group later.
Okay. I just have some screenshots.
Okay, I'll forward it later. Good evening, Mr. Max. Thanks for
Yeah,
joining us.
evening, Juliana. Good to see you again.
Good to see you too. Thank you.
Our superwoman.
We thank God. Thank you, sir.
Yeah.
So we'll just start immediately.
Okay.
Iris will be presenting two of her assignments today. Daniel will be presenting one, and then Benis will be presenting hers also. So let's start with Clarice. So you can do the first presentation, and then you do the second one. No, just do one, then Daniel will do his, Ofure will do hers. Sorry, Benis will do hers. Then you can do the second one.
Okay, can you hear me?
Yes, we can hear you.
I only have the first one at my disposal because I don't have my laptop. I have the copyright and film one. I'm using someone else's laptop.
Okay, that's
but
fine.
I'll try and find it. If I find it, I'll present the second one.
Okay.
Okay, so let me just share my screen. Okay, so this report, I wrote it at that time when the debate about Oloture was ongoing and everyone was talking about it. Even here in Kenya, people were talking about it in the news. People are trying to decipher who owns this, who owns what. So it's copyright in the film industry. Copyright, as we know, protects literary and artistic works like books, music, architectural works, films, videos, etc., sound recordings, name them. And in a film, there are many people involved. This could be the producers, the script writers, we have the directors, we have those musicians whose music is being synchronized, or those ones whose music, whose music is going to be performed by those actors. We have the performers themselves, the actors themselves. So it's a lot of people involved in a film. And because of this, we need to know who is entitled to copyright in a film. So generally, copyright in a film is owned by the person who arranged the film to be made. So this could be the producer, the production company, or the person who commissioned the film. But this differs in situations where there's an agreement. For example, there's a license agreement, or there's an agreement that states someone else owns this and this one owns that, or in an employer-employee relationship like that in the case of Oloture. So it differs. And then in a film, copyright grants the owner economic and moral rights. We know the economic rights, the right to distribution, communication to the public, translation, adaptation, authorizing derivative works, and then the moral rights, which are not transferable. Economic rights can be transferred, but these moral rights, they cannot be transferred. This include like the right to claim authorship, to object to any distortion or any derogative action. So for example, someone is using your copyright in a bad way somewhere, you can object. And then before coming up, okay, let me just scroll down. Before coming up with a film, there are several agreements that one needs to enter into so as to avoid copyright infringement. For example, we have these option agreements, which are used to acquire film rights in a literary work. For example, George R.R. Martin, HBO acquired the film rights to his novel Game of Thrones, and that's why they came up with that series, the Game of Thrones. And then we have director agreements. These are between the producers and those film directors. We have the performance agreements between the producer and the actors to just ascertain who owns the copyright. The synchronization agreements, these are used where music is used inside the film. So for example, the one wants to use a Rihanna song in a film, they have to have a synchronization agreement between them and Rihanna or her recording company. And then we have the film clip or photography agreements. Sometimes you'll be filming and the background, let's say there's a nice architectural work, a building that is protected. You need to have this kind of agreement to ensure that you're not infringing on anyone's copyright while filming. And then product placements. We can see in movies, most of the time we'll see people using iPhones. They're actually advertising for iPhone inside the movie. So this one is mostly popular for advertising brands. So there's need for a product placement agreement. And then we have the distribution agreements. So this one will be between the copyright owner and the distributors. For example, Netflix, copyright owner and Netflix, copyright owner and HBO, copyright owner and Hulu. Yeah, that's all.
Thank you very much, Clarence. I see that a lot of people are like very, very interested in the film industry and how like the legal part of it works, etc. So I think one of the things that I would do is that before this mentorship session is over, I'll just try to get a lawyer that is actually that specializes on film law. I think I saw someone, so I'll reach out to him and see if I can bring him so that he would talk about this properly. But from the knowledge that I have, before I continue, let me ask a question. Um, okay, because your title talks about Oloture, like it has Oloture, copyright in the film industry, inspired by the ongoing debate on Oloture. Is this going to be like a continuous thing? Like, will you still write about it, or this is all?
Yes, I'll write about it.
Okay, because I wanted to find out what is the law for the employee-employer relationship in Kenya. Do you know like what it states there?
Yes, in our law, where an employee comes up with a creative work during work time, uh, during the scope of the work, it belongs to the employer.
Okay, okay. So I will just check our own laws to be sure. I think the last time we discussed this, they actually mentioned the section, so I will just check for it before the class is over, and then I would talk about it. But there is something called like the chain of ownership and all that. So what happens is like what you said, the that's can you scroll up? Yes. So the producer or the people sponsoring the movies, etc. What they do is that they like give an agreement to people that are going to be part of that. Mostly probably an assignment or a license. Then this agreement would actually pass the rights to these people. By the time it passes the rights to them, then it's easy for them to actually go ahead and exploit this. Because if they have all those rights in those people, then it's be hard for them to give it out and all that. You also mentioned synchronization license. Synchronization license is when like a song is being used in a movie, etc. and all that. So most times, yes, most times they give out a synchronization license both to the songwriter and to the um, performer, so that the royalties can be shared. There's a particular sheet that they usually fill by the time they are giving these films to maybe Netflix or to these other people, to TV stations or to distributors actually. So those people would have to account for even the songs that are being played and all that, so that they can pay those royalties and all that. So that's the reason for a synchronization license that is usually used. And then so I'll just confirm the particular section and then I'll read it out. So maybe I'll just call on Mr. Marx to just start his own comment while I check for the section just to be sure, and then get back to you.
Okay. Yeah. Thanks, Juliana, and well done, Clarice, on your presentation. I thought it was, as always, concise, but was in-depth enough to touch on the major issues that one should be looking at when looking at copyright in the film industry. So I'll just give a little disclaimer. I won't be able to comment too particularly on anything that borders on the Olotore movie for conflict of interest reasons. So I'll just try to skirt around it and talk about the other issues. So one of the overlying ideas I just want to throw out there is what Clarice has discussed here actually is almost the way copyright always is when it's in action. Unlike the other rights that stand alone, copyright is always a bundle of rights. So when you see a finished product, it could have up to 100 different copyrights embedded in it. So it's same movie, but right in that movie, you rightly mentioned, there are so many moving parts, so many authors, so many different rights embedded in that movie, the soundtrack, the song, the pictures contained in that movie, and all that. So ultimately, you find that in the film industry, the copyright actually plays such a role that without it, the film industry will not survive. I keep saying this every time I talk. There are certain industries that thrive on IP that without IP law, those industries would not actually exist. So the movie industry or the film industry is actually one of those industries, just like the pharmaceutical industry. Without the complex mix of copyrights and the protection it offers, nobody's going to make the substantial investment it takes to make a movie, because you lose money and you never get your money back. So there are lots of people that must be carried along in the course of working on a movie. So I mean, there are so many things like, and I just look at some of the specific agreements that Clarice has pointed out. It's very important to always have them at the back of one's mind when one is approaching copyright in a movie. So options agreement, of course, is very important, because a lot of times every movie actually arises from some literary work, which would be maybe a novel, maybe an autobiography or a biography. Could come from any different genre of literary work. But what matters is that once that work is going to be made into a movie, then there needs to be a basic agreement with the author of the underlying work. And then, like we said, sometimes that underlying work would actually have different copyrights embedded in it. So for instance, you are trying to make a movie out of a book. And in that book, the author wrote the book, but then in that book also he has included a poem written by another author. So it means that there's another layer of right also embedded. So it means for the lawyer doing the due diligence, for the producer, these are things you have to unearth and ensure that you're getting the license or the permission from each underlying copyright work that is going to end up in that movie. Then I also want to look at the synchronization agreements, also very important. I've had a lot of litigation and a lot of disputes arising from synchronization agreements. So, the songs that are used in movies, there's also a need to ensure that proper clearance is received. And just like I said, also remember that the song in itself is a bundle of copyright. the lyrics itself is actually literary work. The music itself, that's the melody, is a musical work. And then there could also be the performance right of the people who sang the song. That's also another layer of right. So all of this should be looked at holistically when drafting or setting up a synchronization agreement. Then I wanted to give, I think it was a practical example I wanted to give. I can't remember immediately now. Let me see, where was it coming from? Yeah, so of course, product placement agreements also become another very important source of revenue for movie makers. So, I mean, you watch James Bond movies, and there was a time you only used Aston Martin cars, at other times you used BMW cars. So that was, of course, advertisement for those brands. So it come for brands, another huge source of, for producers of movies, another huge source of revenue. So it could even make more revenue from the advertisement placements than they would even make from ticket sales and from the box office people going to watch the movie. So it just means that for a movie producer, you need to have this holistic view in mind when you are setting up your movie to ensure you make as much return on profit. So overall, thanks, Clarice. It was a really good one. Thanks for touching all the important parts. Thank you. So Juliana, back to you.
Okay, sir. Thank you. So I want to try to share the screen. I want to show you. Let me see if I can get it. Can you see my screen? Okay. So I think it's yes, section 10. Subject to the provision of this section, copyright shall be transmitted by assignment, by testamentary disposition, or by operation of law as movable property. An assignment or a testamentary disposition of copyright may be limited. Oh no, I think I'm reading. Okay. Um, Let me see. Um, I think I'm reading the wrong section. Section 9. Sorry. 9, okay. Okay, so notwithstanding subsection 6 of this section 10 of this act, where where a work where a work is commissioned by a person who is not the author's employer under a contract of service or apprenticeship, not having sorry, I'm having some issues here. Okay, I'll get back to this later anyway. Let's just continue so that we don't take time. But
Is it section 9 and 9 sub 2B perhaps you wanted to read?
Yes,
Talking
but I'm
about
it hard to scroll and to do all that. But let's just continue. I think she has been able to explain it a lot, and you've also explained it. So let's just continue so that we don't take time here. Okay, so Daniel, let's hear from you, please.
Okay, good good afternoon to our able mentor and our host. First, I would apologize. I may not be able to share my screen due to the fact that I actually just prepared the slide today. Because I did remember that I was where I was meant to write an assignment. So I had to ask Benny. So I had to call Benny today to seek clarification. But by the next class, I'll work towards that. So I wrote on intellectual property and non-disclosure agreements. For me, I just decided to because I did something. I drafted a non-disclosure agreement this week, so I decided to just take a look into IP and non-disclosure agreements. Um, for me, first I started by stating that we're in a competitive world requiring innovation and novel products. Businesses that would thrive we have to innovate and come up with new ideas, new products and services to have edges over their known and unknown competitors. And these innovations, new ideas, service can be categorized as intellectual property. And as we all know, that intellectual property is one of the most, if not the most valuable assets of a company, even extending to an individual. So now, and we've all agreed that intellectual property are personal rights, and mostly the onus lies on the company or the individual to protect their IP rights, just like they will protect every other physical assets. So they also need to protect these assets. Very, very, very important. But however, it's going to be impossible, or it will be impossible for company for holders of intellectual property to just keep or um, to hold their IP, because they need to monetize these rights. They need to make money off it. And sometimes when these rights are utilized, there's a risk of exposing these ideas, these rights to employees, business partners, investors, and lenders, especially for startups, because startups will definitely need to persuade investors to invest and sometimes to even finance their startup. So at the point of persuading them, they might disclose their intellectual properties, their novel ideas that most times they've not protected, or for instance, patents rights that they would have not even filed or registered their patent to protect these rights. Now, so it is very necessary for these companies, individuals, and particularly startups to think ahead, to be proactive in protecting these their rights. And what one way they can do this is by having a non-disclosure agreement. So for me, I defined a non-disclosure agreement as a legal contract between two parties where one of the parties, that is known as disclosing party, agrees to disclose confidential information to the other party, which is known as the receiving party. And the receiving party agrees to only use the information or for authorized purposes, and not to use or disclose information without prior consent of disclosing party. And I also stated there that, for instance, the popular John Hopkins University, they usually make use of NDAs to protect unfiled patent rights, trade secrets, business plans, and other confidential information disclosed to receiving party. So NDAs can be used to protect confidential information generally, IP rights, which include IP rights, trade secrets, business plans, unfiled patent rights, um, from a receiving party from using that same information to benefit, or from disclosing that information to a third party who might benefit from it to the detriment of the disclosing party. Then I further stated that um, I further went ahead to look at the functions or what NDAs are used for. One, I stated that NDAs are used to protect IP rights and other vital information of disclosing party. So, like I earlier stated, this is one of the major functions of NDA, because sometimes, like what I did recently, the NDA agreement I actually drafted, I was so surprised that the company had drafted, and they were looking to draft an NDA after they had concluded plans to terminate the employment of the employee. So it means that this same employee, every information that he had prior to his termination of his employment, he could use them before the NDA takes effect. But however, NDAs are proactive. They are meant to protect IP rights and every other vital information that are very material and are of monetary value to the disclosing party. So it assists inventors to preserve their unfiled patent rights. Like I earlier stated, for instance, John Hopkins University, they make use of the NDAs to protect unfiled patent rights. So, like we all know that patent rights, the holder of a patent right, or whoever would enjoy the patent right, would have been the one who had filed or first, will have priority. Whoever will have priority in patent right will be the one who has first filed this patent right. So, however, an inventor who has ideas, innovations, inventions, and who has not filed the patent right can have an NDA to prevent the other party, after disclosure of this invention, from going ahead to file this patent right, from using this patent for his own benefit, or from disclosing to a third party who might be faster in registering this patent. So it helps the inventor to preserve his unfiled patent rights. Third, it's is it also helps in distinguishing confidential and non-confidential information. Yeah, in NDAs actually, you should be able to define, or the NDA should define confidential information, non-confidential information. It helps in so that the receiving party would know or have an inkling of confidential information that should not be disclosed. So those are the functions that I was actually able to highlight in the in my assignment. But there are other functions, but those are the ones I was able to highlight. So I went further to state the elements that should be present in an NDA. First, the NDA should state the rights that are to be protected. An NDA should not be vague. It should not just be vague. It should state specifically the rights that should be protected. That would give it binding force. So you should also state the parties that can access the information. You should state explicitly, just like a normal agreement, the parties that can access that should be able to access the information. You should have that. The NDA should have that. Then you should state the length and duration of the NDA. There are some NDAs that are definite and some that are indefinite. Excuse me. But however, for the indefinite NDA, from what I read, I discovered that indefinite NDA can be void. So whoever the disclosing party should be very careful in why draft an indefinite NDA to ensure that it's not the court will not declare it void, and maybe sometimes not ensuring that the NDA is not so restrictive that it restricts the other party from exploring his own ability to make money off the agreement between them, or make money off the contracts both parties have. So another element is the purpose of the NDA. The NDA should state the purpose. It must be explicit in stating the purpose, the reason why there's an NDA. Then another one that I highlighted was release for the breach of the agreement. Well, I really don't know, but I think for me that NDA should state the reliefs, and chief of these reliefs is injunction. So when a party has started breaching um, the NDA, the other party, the disclosing party can run to the courts to seek for injunction, preventing the other party from further breaching the NDA to its detriment. The other element that I stated was jurisdiction in the event of breach. Yes, the NDA should state jurisdiction to avoid technicalities in courts and to avoid any issue of but although this is a bit dicey for me, it's a slippery slope, because normally I know that parties do not parties cannot confer jurisdiction on the courts, because normally the courts derive its jurisdiction from statutes and from statutory law. So it's a really bit dicey. But from the little research I did, um, the from the different authors I read, they were of the opinion that parties should state the jurisdiction that's in the event of breach. But I'm believing that when parties are stating this jurisdiction, they also need to look at the laws, the relevant laws, in identifying the exact court, the appropriate court that would resolve the dispute, any dispute that arises from the NDA. Then I went further to state that um, yes, even after a disclosing party has done all that is necessary, the disclosing party should also take reasonable steps to ensure that the receiving party does not breach the NDA. Um, Failure to do so might actually be difficult for the disclosing party to enforce the NDA in courts. Although I looked at a case, not a Nigerian case, I tried to look for Nigerian authorities on this, but I could not lay my hand on any. But I found a case from a 2008 case from the Northern District of California in the United States. there the court refused to rule that an information in the NDA was a trade secret, and also further refused to grant an injunction preventing the defendant from selling copies of the information. And the reason was the court hinged its decision on the ground that the plaintiff had not taken any reasonable step to preserve the confidentiality of the information. So, with having failed to take that step, it was showing, or it was establishing the fact that that information was not confidential, and the court was of the opinion that the measures that the plaintiff would have taken in preserving the confidentiality of the information were not expensive measures, were simple measures. Actually, it was an NDA between an employer and an employee. They were simple measures of informing the employee of the the essence of that information and the confidentiality that is involved with the information. But although I might not be able to agree, I do not agree with the judgment, because I believe that once there's an agreement and a party has entered into an agreement, the party is bound by the terms of the agreement. But that was what the court said, and I don't think the plaintiff appealed to an higher court to overrule the district court. Now, I concluded by stating that IP rights are personal rights, and the onus is on the holder of such rights to take all necessary steps to protect such rights. I think from the last class we held with the partner from Aluka and Ayubode, she emphasized and underscored this fact that IP rights are actually personal rights, and the holder of an IP right should not be waiting for the government to protect these rights. It's not like so it's, and because mostly the beneficiary of this IP rights is the company, the holder of the IP rights. So every holder of an IP rights should take every necessary step to protect the right from being explored or being exploited to their detriment. So I also further stated that every company, particularly startup, should have ANDI and NDA before going into any contractual relationship to preserve the IP rights. Like I said, I was given the task of drafting an NDA, but I looked at it that yes, the employer was drafting an NDA to prevent the employee from using or exploring every information that or and trade secret that the employee had already had been disclosed to the employee during his employment. But the fact remains that the employee would have can use every information he had before the the NDA agreement was drafted and before he signs the NDA agreement. So it's proactive. It's every company startup should have an NDA agreement before going to any contractual relationship to preserve the IP right from being explored. I think it's the ideal thing to do. So, however, but I believe that an NDA agreement should not be unethically used to silence a competitor or an employee. Sometimes it should not be taken overboard by the disclosing party by to prevent most like an employee to restrict an employee from using this same so from using certain rights or from exploring a bit of it to for their own economic benefits. It should not be unethically used to silence a competitor from um, from competition, because sometimes a disclosing party might take it overboard to silence his competitors or employees. Otherwise, such NDA agreement may be declared void by the court on public interest and on public policy. So that's my presentation.
Okay. Thank you very much, Daniel. This is like a very comprehensive analysis of an NDA, and I've actually learned a lot from it also. So I know from relating with clients that what you said is true. Like a lot of people wait for business to go through and all that before they think about putting an NDA together, even in an employment that's between an employer and employee. There's also that issue of, okay, they sign it and all that. And I think that's the reason why some of these companies have like maybe like an HR department that is in charge of ensuring that some of these things are done. And then for contractors also, some have issues. contractors or consultants, majorly consultants, people that go and they submit proposals, etc. Some also have that issue where they go and they submit proposals and then someone else changes the name and all that. And people also have the issue of they might be going to submit something and the people that they are submitting it to might refuse to sign an NDA. So people that they bring those ideas to, they might say they don't want to be tied down by an NDA because they receive ideas and pitches every day, and you might not be the only one who has actually done that. So if you bring that to them and they sign your NDA, what if someone else brings it to them and they choose to work with that person? You might now start saying that that they actually stole your idea when they did not. So these are some of the issues that people might have for NDAs. And then for franchise license, it is for franchising, aside from the fact that they give you like their trade secrets, that's like things that you should do and how the look and feel of the place should be, they also share their trade secret. And so they also try to ensure that those non-disclosure agreements actually signed. And for patents, the standard for patents is high. So for a startup, they might have to weigh it. They might weigh the cost and they might weigh if their business will actually, that's their idea will actually meet the standard of getting a patent. So they might decide to go with a trade secret. And if they go with that, then they would have to use a non-disclosure agreement for the employees that will be coming in contact with those informations that that are commercial to them and all that. So another thing again is there's something called WIPO proof, but I don't know if you've heard about it. So it's also like a data protection kind of system, and then they give you tokens, they give you keys and all that to be able to protect like the information and all that. But that was a very good presentation. Thank you very much, Daniel. So let's move to Mr. Marx. Yes. So please.
Thank you, ma'am.
Thank you.
Yeah, okay. So thank you, Juliana. Thank you, Daniel, for that presentation. You have actually talked about something that is a raw nerve. I mean, it's one of the IP disputes we hear of most often. I mean, if anybody remembers, sometime I think in 2016 or 17, we had this controversy where Nigeria launched a rebranding program, Change Begins With You, and some consultants turned up and said, well, we presented this proposal to the Ministry of Information and Culture, and then they told us they were not interested in the proposal. We turned our backs, and 2 months after, they launched the program based exactly on our proposal and copying everything that were presented to them. So of course that throws up the same issue like Daniel's presentation shows. You may have an idea, but you don't have the funds to execute your ideas. You don't have the technical capacity. You don't have the authority. Sometimes it's the government that can implement those ideas. So you need to interface with those third parties to actually get funding or to get the technical support you need to be able to exploit your idea. So it becomes a challenge because at that point, I mean, nothing stops. There's another very popular case in Nigeria as well, where it was a case of some young people approached a bank with a proposal for a savings and loan scheme. Barely a few months after, the bank came up with exactly the same program. And of course, the guys cried wolf went to court, and at some point they settled. So the matter didn't go on point. So what that tells us is, when we look at it, another angle we need to look at it from is the unequal bargaining power that usually comes in. The startup who has the idea and all, it doesn't have all the financial muscle, it doesn't have the power, it doesn't have the finesse, he's maybe not even able to afford a lawyer to put some of these basic things together. So he goes for this meeting all alone, and then he easily gets fleeced by the more sophisticated financier or third party who has technical capacity and the money needed to execute the project. So it's a challenge, first of all, for IP lawyers to first and foremost ensure that they're able to execute, or they're able to bring this this knowledge to the level of the SMEs and those players at that level. But another important thing which Daniel has mentioned in his presentation, which people overlook easily when it comes to NDAs, is that NDAs also have a public policy element to it, where the government also does not just want to let people create monopolies or stifle competition, in the guise of signing NDAs, or in the guise of saying, look, I've come up with something and I don't want anyone else to get into it. Because the government also understands that that knowledge, that idea you have is a benefit to the public, and allowing you monopolize it means that you could get to a point where by the time you exploit and release that idea to the public, because you have a monopoly over it and nobody else can offer the same idea or services, then it means that you could actually hike your prices, you could lower your quality, and there's no alternative people can run to. So it means that even if your prices are exorbitant, people can run to an alternative because you have shut out all the competition from the market. Even if your quality is poor, people can run to a competitor, an alternative, because you have locked up the market. So yeah, so Daniel is right in pointing out that point, which is very important. In drafting NDAs, you need to understand that there has to be a balance. You need to look at it from the viewpoint of what is most beneficial to all the parties involved in the transaction, not just looking at it from the viewpoint of scaling up everything, on the side of your client alone. So that is, I think, an important point that he has made that we need to look at carefully as well. So thank you, Juliana. Back to you.
Thank you very much, Mr. Marx. Okay, so we'll move to Bernice.
Hello. Good evening, everyone.
Good evening.
Okay, my presentation is on digital technology and trademark. I can't share my screen because I don't have a system.
Okay.
Okay, so the advent of digital technology and the internet has brought about a geographic growth in e-commerce business. So businesses now have websites, social media handles that are even more proactive than their physical offices, or yes, physical offices. Domain names are like titles that lead people to the website of businesses that have created an online presence. It also stems from, domain names also give businesses online visibilities. Yes, visibilities in their businesses. So if I have a domain name present, people can easily be directed to my business and services. Sorry. Yes, people can easily be directed directed to the website to see a full profile of my businesses. But looking at the Trademark Act of 1965, a lot of the online digital environment is not really protected. The only protection that a lot of businesses have is under common law, which is passing off. So somebody can go and register a similar name, because domain name most times comes from the business names or registered trademark. For instance, if the name of my business is Ben's Asen, and I register, if I want to get a domain name, it's going to be www.bensasen.com. So somebody else going to register, although I have trademark in it, somebody can go and get the domain name because it is not protected under the purview of any law aside passing off. So I was trying to point out how that the law needs to be looked into and addressed, because there was a case of Shell International Petroleum and Co. I cited it against Alan Jones, where the website or the web address of Shell International Petroleum was www.shellnigeria.com, But Ellen Jones went ahead to register a domain name that was very similar. That was www.shell_nigeria.com. And the court held that it is likely to cause confusion and direct people who are like customers of Shell Petroleum to that. So a lot of times people also go and register names that they do not have businesses with. There should be a law that states that if you've not registered this business, if you do not have trademark, we cannot give you, this domain name. But we see that every time if you go on GoDaddy, a lot of business name that has been trademarked, that has been registered, are still very much available. So people can do that in bad faith, and will wait for you to, maybe when your business is big, they will now sell it at a higher price. They will sell it, maybe I don't get a domain name at the time I'm starting my business, and now I have over 100K followers on Instagram, and I want a website. I have to go and buy it from somebody else who has registered it at an exorbitant price that I can't even afford. And they'll be able to pass off my business. They can be doing anything. They can even give people to, squat on the site and take away from my traffic that I'm driving from my maybe Instagram or Facebook page. So the law doesn't really provide for any guide as to how the digital environment can be protected. Although there was a bill that stated that a bill criminalizing the use. No, there was a bill that was passed. The title of the bill, there was a bill that was brought before the National Assembly, and the title of the bill was Cybersecurity and Data Protection Agency Bill. But the bill did not see the light of day. But there was a section or a clause in the bill that stated that criminalized the use of computers to violate intellectual property rights protected under any law or registered in Nigeria. But that was the closest that they went towards protecting online businesses as it relates to the digital environment. So I basically just talked about how that the law can change the trajectory of this story and, be revamped to suit online businesses and e-commerce that have websites and, intend to have a domain name. That's my presentation.
Okay. Thank you very much, Bernice. Actually, I agree with you. Like, it's like an issue that a lot of businesses have. And I think it's majorly, I think even in China, they have that issue there because they know that a lot of businesses, when they think of expansion, they would want to expand to China. And so by the time they get there, they discover that someone else, they even go as far as getting the domain name and registering the trademark there too. So by the time they register the trademark and you come, then they would have to sell both the trademark and the domain name and everything to you. And that's, I think this topic is what the mentor for last week, Maria, spoke about. And at that point, I wasn't able to attend, but I know that WIPO has something that they have a center or something that is channeled towards disputes that arise from domain name issues and all that. And I don't think it's so expensive. So you get a neutral and then you pay a certain fee and then they do that for you. They're also trying to discourage that in China and in some other countries. But as you said, in Nigeria, the bill that you spoke about, I'm not aware of the bill, but it will be something that will be very good for Nigeria so that, because I know that there was a particular story that I heard of someone who was in a restaurant and he was talking about his domain name, his business and all that. And while he was talking about it, his voice was a bit loud. And then the person that was beside him decided to go and register the domain name. So those are things that happen and all that. And the way it is, like, if CAC and the trademark registry cannot even get to the point where they work together to say, okay, if you registered your company here, then you should not be able to trademark someone else's company, then you can imagine how long it would take for us to even move from the CAC point to trademark and to the trademark registry and then move to domain name. So I think that we might be looking at a long road, or not too sure, but thank you very much. Your presentation was really insightful. So let's move to Mr. Marx. Mr. Marx, please.
Okay, yeah, thank you, Juliana, and thank you, Benis, for that presentation. Yeah, so I believe you guys had the session with Maria Koval last week, right?
Yes.
Okay, excellent. Okay, and but of course I heard some of you struggle maybe because of the accent, and she's not a native English speaker, so I know it's not always easy, but she's very experienced in this area because she's actually a member of the panel of neutrals of the World Intellectual Property Organization Uniform Domain Name Dispute Resolution Procedure, which is the foremost place where you resolve domain name disputes. In fact, they have done, as at last year, September, they have done 50,000 cases, and they do their cases with a lot of speed. I mean, they have cases from start to finish, tops 6 weeks. So in a month and a half, you already have a final decision from that body. It's like an expedited kind of arbitration with specific rules. But however, I just want to point out something, Benis. You could look at this, and I'm sure it will enrich your perspective. There's actually a law, the Cyber Crimes Act, provides punishments for cyber squatting and for some of these offenses you have mentioned. So you go and take somebody's trademark and register it as a domain name. You actually can be punished under the Cyber Crimes Act 2015. So there's criminal punishment actually for cyber squatting. And then there are other forms of, so cyber squatting is where you take somebody's registered trademark and register it as a domain, and essentially, of course, you are able to deceive and attract away customers or people who are actually online looking to connect with the legitimate owner of the trademark. But there are other invidious forms of digital malpractices with trademarks. So there's what we call, for instance, typo squatting. So for instance, I decide to register a domain name, and my domain name is spelled G-O-O-G, then I and E. Now that's Googie. But anybody looking at it easily, because I and L look the same, would think that is Google. So if I can register www.googie.ng, anybody seems to think, oh, Google has launched a new website for Nigeria. So that also is called typo squatting. It's also a form of trademark malpractices, digital malpractices, in respect of trademarks. Then there's also other forms, so including that. But what is important, or what is good to note about this, is that why it's so difficult to find a solution really when it comes to cyber squatting and misuse of trademarks on the digital environment is that we need to understand how the internet works. The internet, as we understand it, actually is computers essentially communicate with each other in binary. Binary means that they communicate in ones and zeros. That's how computers speak to each other in essence. So at the basic level is the binary language. That's ones and zeros. So 0, 1, 0, 1, 0, 1 is how those is just essentially a magnetic, not magnetic pulse, but electrical pulses. That's how computers communicate. But when they lump those communications up, for computers on the internet, on the network to work together, what happens is just like your telephone. When I want to call Juliana Imam now, her number could be 08065 something, but I don't always have to remember that number. To make it easy for me to connect with her, I simply store her number against a name, Juliana Imam. So when I want to call her, I go to my phone book and I look for Juliana Imam and I call her. But my phone number is not going to be sending out Juliana Imam as a code to search the MTN network to connect to Juliana Imam. It will be sending out the number attached to that name. So the phones communicate with those numbers. Computers on the internet work exactly the same way. They communicate with numbers. So each computer connected to the internet has a unique number, what we call the IP protocol. As it's a long series of numbers, just like a phone number, but even longer. So when I want to search something on the website of, for instance, the Nigerian Corporate Affairs Commission, when I type in www.cac.gov.ng, which is the domain name, there's a number, the IP address. My computer is going to search for the IP address, the IP number of the CAC computers, and then it can connect to the CAC computers and get the information I need for me. So what that means is that the domain name system now, there needs to be somebody who controls how we pair numbers, that's the IP addresses with domain names, with the what we can memorize is csc.com or google.com. So that organization is called ICANN, that's Internet Corporation for Assigned Names and Numbers. So their function essentially is to ensure that there's a registry that maintains the names given to the domain names given to each computer. So it is through that system that you are able to connect and find the computer you are looking for on the internet. So that's one layer of complexity. Now, initially when the internet started, it was simple. There was only one domain extension. That means all domain names ended with .com. So it simply meant that the moment I register google.com, nobody else will be able to register Google as a domain name anymore, because the only available extension to use to register Google is google.com. But subsequently, more domain name extensions, or what we call the top level codes, were added. So for instance, .int for international organizations. So like JIIPCC.int for international organizations. Over time, of course, more were added. So we have www.co.za, for instance, which is unique to South Africa, www.google.ng, which is ng is unique to Nigeria. But the internet is soft. Well, I won't say software, but the internet had a remarkable event in 2015 to 2016. What has happened now is that there's no limit anymore to the domain name extensions that can exist in the world. That's why recently you see domain names that look like www.google.africa. You can have domain names that is www.google.lagos, google.nairobi. So it means that that last extension now has an infinite number. So unlike before, where all you had to do was just to protect your trademark with .com, now it means that by the time you protect your .com trademark, somebody can go and register .ng. So Google, for instance, I can go and register google.ng. Google has to come after me and get that away from me. I could move immediately and go and register google.com.co.za. They will come after me and get that. I could go and register google.africa, google.lagos, google.abuja. So it's become an infinite possibility. So what it means now is that protecting yourself online has become a lot more difficult. So that is why the WIPO Center I spoke about has done 50,000 cases in just 20 years. They started in 1999. So in just 20 or 21 years, they have done 50,000 cases. We expect that number to really shoot up as people are able to use more domain name extensions to keep, perpetrating cyber squatting. So it's not a problem that is going away anytime soon. And then what the ICANN has done, because the WIPO Center that does domain name dispute resolution center is kind of a joint collaboration between ICANN, the organization I told you about, and WIPO. But what they have done is, because I've seen that the numbers are exploding, so they have licensed other arbitration centers around the world to also run the same expedited domain name dispute resolution system. So we have one in Asia. We don't have any dedicated to Africa yet, but hopefully very soon we'll get something in Africa. I know in Kenya, Clarissa, I don't know if you know about this, but there's the ICANN, that's the Internet Corporation for Assigned Name and Numbers. They have an office in Kenya, so I know there's a lot of work going on in Kenya. So we expect that soon there might be a center for resolution of domain name disputes in Africa, maybe likely cited in Nairobi. So it's not a problem going away anytime soon. So it's going to be an interesting area of the law. And then, of course, added in the Cyber Crimes Act, many countries have the criminal punishment also for cyber squatting. So we'd expect to see a lot more action in this area as we go along. Okay, so thank you, Juliana, back to you.
Wow, that was really intense. Thank you, Mr. Marx. Clarice, would you be able to make your second presentation today, or you've not been able to get it?
I was not able to get it, but I can just present on it.
Okay, that's fine.
I don't have a backlog.
Okay.
Okay, so it was actually a report on franchising as a way of commercializing IP rights. So franchising basically is where a franchisor grants a franchisee a license to trade under its name. And this has become a very popular way of exploiting IP, since the franchisor allows the franchisee to manufacture, to distribute. For example, Coca-Cola has distributors in almost every country to sell a product or to run a business. For example, KFC, we have Woolworths all over. Yeah, those are types of franchises. And then it's also popular because the franchisee is able to enter the market more easily, since the business is already there, it already exists, and the franchisor has already established a brand, so the franchisee can get clients and is able to run the business easily. And then basically franchising is it means that the franchisee is buying the right to use the franchisor's IP. So it could be a trademark, it could be copyright, a patent. So the franchisee is just buying the right to use those intellectual property rights. And before they engage in this kind of agreement, the franchisor needs to ensure that all his or her IP are registered. And on the other part, the franchisee should at least conduct due diligence to ensure they're working with a legit person who owns those intellectual property rights. Sometimes you can enter into a business and find out the person who was claiming to be an owner of a certain IPR is not the said owner. And because of this, to avoid any disputes in the course of the business, they should be able to sign a franchising agreement which will set out the rights and the obligations of the parties. And the NDAs will also apply. Since Daniel already explained a lot about that, I won't go deeper into it. And for franchising in Kenya, we don't have a specific legislation. I don't know about Nigeria, but we rely on competition laws, the consumer protection laws, and the IP laws. I guess that's all I can present for now.
Okay. Thank you very much, Clarice. I think this is a very interesting topic, actually. And I don't know how well we actually take advantage of this in Africa, because I know like most things come this way. We are like more consumers than the other way around. So but it's something that it's very important. So it's like a bundle of IP rights that comes with the franchising agreement. Like they give you everything that they have, including their trade secrets. So from like the look and feel and how they're able to make their sales and all that. So they share it with you, and they have to ensure that those things, those informations that are shared with the franchisee is not actually open to the public. So an NDA is extremely important when it comes to a franchising agreement and all that. So let's just move to Mr. Marx so that he can discuss further. Thank you.
Okay, yeah, thank you, Juliana. And thank you again, Clarice, for that very incisive, even a very brief discussion on franchise. Yeah, franchise is a very interesting area of IP law. It's one of those industries that, it's in substance IP law. So, franchising would not, as a business model, would not exist without the support and the very active collaboration of IP law. I want to point out a few things that people might overlook when it comes to franchising. Now, when you do a franchise, of course, you are given a bundle of IP rights. So there'll be copyrights involved. So for instance, if you are taking out a McDonald's franchise, you are getting a copyright licenses to use their menus, for instance, which are subject to copyright. There could even be theme songs that they use in their outlets, which is also subject to copyright. You're also getting trademarks, the logo, the name of the brand. You are getting elements that will be more passing off trade dress, how the shops look, the kinds of chair to use, the shape and the color of the place and all of that. You are getting, of course, patents that will include maybe inventions that they have that makes the business run. You are getting trade secrets, things like menus and other unique formulas. It could even be accounting formulas, marketing formulas, marketing information and all of that. You're getting, of course, all other forms of confidential information. So it's a bundle of rights. So whenever people look at franchising, it's just like a movie. For instance, we spoke about the fact that how copyright works in a movie is a bundle of rights. So for instance, for a lawyer doing due diligence in a franchise agreement, you're having to look at a lot of things all at the same time and having to give a lot of in-depth look. But I want to touch on one area people don't seem to be aware when it comes to franchising. Now, in franchising, essentially, you are licensing the franchisee. The franchisor is licensing the franchisee the right to use intellectual property to run a business to certain specifications. And of course, there usually will be control of quality and all of that involved. Now, why this is important is that when it comes to trademarks, we need to understand that all IP rights are subject to licensing. Trademarks can also be licensed, but when it comes to trademarks, there's some variation to it. You can't, in a sense, purely license the right to use a trademark without a similar quality control measure. The reason is that, remember what trademarks are for. The law allows you to use trademarks to show as a source identifier so that the public understands that any goods that bear this trademark is coming from a certain producer. And the public therefore relies on that trademark to become a seal of quality. So you can't license your trademark to a person without control, without any control on quality control, because immediately if you do that, that means that that trademark stops functioning as a trademark. Because if it's a trademark, then it should always mean that people who bank on that trademark are actually getting goods to a certain specification and quality, goods that come from you. So it means if you simply give your trademark to somebody to use without any quality control, without any supervision, then it means that you have created a disconnect between that product and the quality assurance that the trademark should function as coming from you. So that part needs to be answered. And that is why in a franchise agreement, there's a lot of control. You don't just throw the franchise and let the franchisee run. There's supervision, there's regular checks, there's regular inspections, to ensure that the quality is being maintained. Then lastly, on the point Clarice mentioned about, unfortunately in Africa and many countries in the world actually don't have specific laws governing franchises. So franchises are governed just by agreements, by regular, the regular commercial law that governs agreements. So whatever the agreement says is what the court flows with. In the US, for instance, there are very specific laws about franchising, how it should be done, what kind of rights. Because if you look at the franchise agreement, it's like what you mentioned, there's unequal bargaining power. The franchisor, McDonald's, is that huge big guy. The franchisee is maybe just somebody who retired and wants to use the pension to invest in a business and says, look, I don't want to start a new business because I don't have, age is not on my side and I don't have the capacity at my old age to start in business. I'd rather just invest this money and take out a McDonald's franchise close to my place. So the law understands that that person needs to be protected because he's taking a lot of risk. The big guy is already there. He's not taking as much risk. You, the franchisee, you are paying for a lot of things. Some franchises even make you, the franchisee, pay for advertising and so many other things. And then there are guaranteed payments you have to make to the franchisor. So sometimes the law comes in to ensure that there's protection for the smaller guy. That's essentially the franchisee. So in Nigeria also, we do not have a specific law on franchise. But however, there are certain laws that are implicated once you enter into a franchise agreement. So in Nigeria, for instance, we have a law called the National Office for Technology Acquisition and Promotion. So what that agency of government does is to vet agreements that involve technology transfer from foreign parties to Nigeria. And the essence is just to ensure that when there's technology transfer, Nigeria should not continually pay for technology without an effective and actual technology transfer. So in a franchise agreement, usually there would be some transfer of technology, how to prepare, marinate chicken, and how to prepare a particular menu. So those agreements are actually subject to regulation. They have to be registered with the NOTAP, and NOTAP has to examine them to be sure that these agreements are also not simply used as a tool for transfer pricing, which is essentially to just move tax away. So for instance, if there's no regulation, McDonald's can come to Nigeria and say, and maybe they just want to shift their profit from Nigeria and ensure they don't pay tax in Nigeria. So they can simply say something like, for the technological know-how that we have given to our franchisees, each franchisee must pay us $1 million every year. And the question you ask yourself is that if the franchisee was to buy the same knowledge on the open market, how much would he pay for it? Would he be able to buy the same thing for $10,000 US? And if he means he can buy for $10,000 US, it means that if you allow McDonald's to do that, McDonald's is taking money away, $990,000 away from Nigeria could have been taxed in Nigeria. So that's why this law is coming to play. So I want to suspect, Clarice, if you check, there should be a similar law on technology transfer in Kenya. So do a little research on that, and let's see. I believe there should be a similar law in Kenya as well that ensures that you register franchise agreements and get approval from the government before you can launch out your franchise business. Thank you, Juliana. Back to you.
Thank you, Mr. Marx. Are we not so lucky to have Mr. Marx here, because he's so insightful and very knowledgeable about IP, and thank you so much, sir. We really appreciate your time. Thank you for the time that you put into this. Thank you for the efforts that you take into reading all the assignments and making sure that you give us valuable contributions to our presentations. Thank you, Clarice. Thank you, Daniel. Thank you, Bernice, for attending.
Thank you, Ma. Thank you, sir.
Thank you, Ma. Thank you, sir.
Thank you. Next week, Mr. Folarin will be taking us on IP litigation, opinion writing, etc. So for those of us that are practicing, it's very good for us to come, and there might be some things that he would say that would help us. Because I know he said something like, there was a particular statement that he made about not really losing an IP case before. So not really, but something like that. So I'm just saying that it would be good. And Mr. Marx, you can also join us next week, Friday, because I know that you're also when it comes to litigation, it's fire, you finish it. So please come next week so that by the time Mr. Folarin gives us from this side, you can also add your own contributions also. So thank you very much, everybody. Hope to see you next week, Friday. Lovely weekend, everybody. Bye.
Thank you. Bye.
Thank you.
Bye.
Thank you, man. Thank you.
Bye. Thank you all.
Bye.
Have a lovely weekend.
Thank you.
Yeah.
Thank you, sir. Bye.